an argument that power should be given back to the courts, so that individual mothers, fathers, who've got care of the children can take court action to get financial money for themselves and for their children through the courts, instead of having to rely on the TSA, which has been notorious for being collecting money for children and men. The other thing I'd like to say is that maybe the family court ought to be expanded. I mean, that's what I'll be arguing later, that maybe we ought to be removing the family court to a certain extent out of proceedings. But in the case of people with mental impairment or mental illness, there's been a history of institutionalised violence against patients in mental hospitals. And maybe these patients, okay, they have visitors, but maybe there's a case for guardians to be appointed for individuals so that their voice is heard, and the fact that these abuses have been going on and would actually stop at Parliament to investigate that seriously. I'll now go on about the Children Act. Children Act 1989 was brought in by the Conservatives. It is one of the a very good piece of child-centred legislation in general. The Children and Family Court Advisory Support Service came into being on the 1st of April 2001. And there is a question mark is what actually made the rules joke. Look at that. CAFCAS provides welfare reports in most cases. I was actually involved in the consultation process that led to CAFCAS as a key stakeholder. CAFCAS has quietly got rid of its key stakeholders. They now say that we are interested parties, and they're supposed to, I'm an interested party to find out by CAFCAS, and they're supposed to meet me twice a year for me to raise individual concerns about case studies. Last year they met me once, and this year there's no meeting scheduled, so I'm quite worried about that, because the stakeholder idea brought in the fact that Lord Justice thought, decided in case law that we didn't have the automatic right to cross-examine court welfare officers. CAFCAS officers replaced court welfare officers, and a statutory instrument came in on the 1st of April which allowed for the cross-examination of CAFCAS officers. So that was a change in the law. Unfortunately, CAFCAS brought in new national standards, but in them there's very, very little reference to parents. What about children? There's very little about parents. The original national standards, I haven't got copies for everyone, so you can have a look at these. The original Home Office standards were quite comprehensive in things about meetings, timescales, schedules, the fact that opinion should be designated as opinion, not fact. So if anyone wants to have a look at that, and I'll show that later. The CAFCAS officers are referred to as the eyes and ears of the family court judges. But does that make judges blind and deaf? There's a question mark about that. The Children Act 1989 removed the natural guardianship of fathers and replaced it with parental responsibility orders. Could this be a cause for discrimination against fathers? Lessons from law. That's one criticism I have, main criticism I have of the Children Act. The family courts, as we all know, have become a bear pit with false accusations abounding. There's been a form of double jeopardy that's been introduced into the family court. Often defendants are found innocent in the Crown Court and then later found guilty in the family court. The punishment is the loss of their children. The standard of evidence in family courts is less than in criminal courts. When I first started working, I'm actually a national executive member of the Mankind Initiative charity, as well as being a coordinator for the Family Law Society. Much of my work in the Mankind charity used to be helping men. In recent years, many more women have been seeking our assistance, and that's quite a worrying trend. There's discrimination against mothers as well as against fathers, I'm afraid. In recent years, appeals have become much more difficult. Restriction notices have been placed on non-resident parents, forcing them to get the leave of the court before they put in any applications. Fit parents are being denied justice. CAFCAS does not allow complaints against the content of its reports. It would be a good quality control measure if parties to family law proceedings were allowed to make complaints against the content of CAFCAS reports. The government has turned a deaf ear to complaints about CAFCAS. It will not hear individual cases, which is absolutely absurd. The problem is compounded by the fact that the National Association of Probation Officers operates under an anti-sexism policy which promotes the exclusion of men from the lives of their children as the family breakdown. NAPO provides the main trade union for CAFCAS officers, so men enter the family court at the peril. If they're up against a CAFCAS officer who's also a NAPO member. Mark actually made reference to the fact that over 90% of British disorders are awarded to women. Before the Children Act came into being, there was a lot of talk about shared residence, shared custody as it used to be called. That seems to have mostly gone out the window. Most men give up everything and concede everything to women, so they know that if they resort to the court, they will discriminate against. Many cases don't actually appear in the courts, many situations. Parents actually go on and organise things themselves. Many men feel that family courts are a meat processor. You go in one end with your children and come out the other